Hello, thank you so much for joining us today. We are here for our second webinar with CLASI and the Disabilities Law Program. Today we are talking about the Return to School Roadmap, and we are in particular talking about IDEA Part B, the development and implementation of IEPs. We have Stephanie Ramirez here with us, who is a staff attorney now. Congratulations, joining us and to talk about this very important topic. We're going to start. This is just the agenda. We're going to talk about who we are. We're going to look at the Return to School Roadmap, where you can find this information. We're going to do a quick, I don't know how quick, it is IDEA, overview of Part B, and in particular focus on the guidance around Part B and IEPs. Stephanie, you want to talk about CLASI and the services that you provide?
Sure. So Community Legal Aid Society is a civil legal services, and we provide free civil legal services to vulnerable and underserved Delawareans, including those with disabilities. We have a bunch of different programs, including fair housing and immigration unit. And then I am a staff attorney in the Disabilities Law Program. And that serves as the protection and advocacy system for the state of Delaware. We provide advocacy on behalf of individuals with disabilities, including students with disabilities. And the advocacy that we provide is individual advocacy, which is individual cases, or it could be systemic advocacy if there's a large issue that's happening for a bunch of people. And then we also provide information, referrals, and provide technical assistance.
And we are the Parent Information Center of Delaware. We are the PTI, the Parent Training and Information Center for Delaware. We serve all 3 counties, and we serve families that English is not their first language, from other communities and countries. Our goal is to support youth advocates, families, and children with disabilities and the professionals who serve them. So we do this in a number of ways with various programs. In our PTI, our Parent Training and Information services, we do one-on-one consultations with families about their children's educational path and goals, IEPs, 504s, any educational services that they are exploring, that they are working with the school to put in place for their children. We do training and workshops and webinars for families and professionals in the community. And we have online resources, so you can find our information and information from our community partners like CLASI on our website, which is pickupdel.org. We also have a weekly e-news that goes out every Thursday, and you can find the link on our webpage. We also have it in Spanish. We have one that is focused on transition age youth, and we have one that is focused on early childhood. So please look to our website for those resources. So this information that we're going to share with you today comes from the Department of Education, the U.S. Department of Education, and you can go to this website for access to the actual documents. We are going to be talking about what's in there, but you can go and view those documents. And the intended target audience for these documents are educators, school leaders, parents, families, and communities. So the goal, which we talked about last time and we'll briefly talk about today as well, is to prioritize the health and safety of students, school personnel, and their families, to build school communities and support students' social, emotional, and mental health, and to accelerate academic achievement. So this is why this school roadmap, return to school roadmap, was created. So the guidance documents talk about different parts of IDEA. So Part B, which last week we talked about child find under Part B of IDEA. And that piece of the roadmap was published August 24th of last year. Today, we're going to talk about the development and implementation of IEPs. And that guidance was published September 30th. And we are going to next week talk about Part C, so child find. And Stephanie, you want to start with the overview?
Yeah, so just a quick overview of IDEA, or Part B of IDEA. So that is the federal law that provides for special education. In Delaware, we have an equivalent law called Exceptional Children. And on this slide is where the actual law, the statute, can be found for both the IDEA and then exceptional children. And then also where the regulations can be found, and the regulations are the rules, kind of how those laws are implemented, right? The procedures and everything that you've got to follow. So the purpose of Part B of IDEA is to make sure children have a free, appropriate public education, and that is special education and related services that are designed to meet their unique needs and prepares them for further education, employment, and independent living. One of the hallmarks of IDEA and special education and related services is that it is all individualized. So it meets the student's unique needs, right? Every child is different, and every child is going to need something different. And Part B of IDEA specifically applies to children with disabilities who are ages 3 through 21 inclusive. So it goes generally up until they turn 22. In Delaware, we provide special education and related services under IDEA up through the end of the school year in which the student turns 21. Or up until they achieve and receive their high school diploma. And so IDEA also has, it's there to protect the rights of children and parents, help schools and the government educate all children with disabilities, and also make sure that that education that's being provided is effective. So Part B of IDEA has 8 subparts, and it's a big law. It's got a lot of stuff, but the main chunk of IDEA is Subpart D and Subpart E. Subpart D has all of the information and everything in there about actually conducting evaluations, when they need to be conducted, about determining eligibility for special education and related services, individualized education plans or programs, IEPs, placements. And then Subpart E is all about the procedural safeguards and due process procedures. So what the parent and students' rights are under IDEA and how to enforce those rights. So now we'll get into the actual guidance, and I'm going to put a link to the guidance that we'll be talking about in the chat. It's about 30 some odd pages long, and it's a Q&A format. And this is from the U.S. Department of Education, as Tina had mentioned earlier. And it's really accessible. It's meant to be that way for the public, not just for professionals. And one caveat I do want to make is that the information here in the presentation is not supposed to be considered legal advice. Although I am an attorney, this is just general information that's being provided. And if you have some individual questions or individualized questions that are particular to your situation, you should feel free to contact our office or contact PIC for those questions. But if you have some general questions about the information that I'm going to be sharing, feel free to drop those in the chat, and we can get those answered. So in this guidance that we're talking about today, these are the different topics that are covered in the guidance. I'm not going to read through them all. You can see them here. It's all about special factors to consider, annual goals, and also looking at those disagreements and how to enforce your rights. And one important thing is, even though the pandemic has happened and is continuing to happen, it does not mean that students lost their rights under IDEA. All those rights are still there, and children and students with disabilities are still entitled to a free, appropriate public education. And it didn't change. All right, so must the LEA or the local education agency, and that's your school or school district, do they have to make sure that there's an IEP in effect at the start of the school year for every student? And the answer to that is yes. If they have identified a child who is eligible for special education and related services, an IEP must be in effect at the beginning of the school year. And it must be individualized, appropriate, and designed to provide that free, appropriate public education. However, that does not mean that there has to be some IEP meeting that happens prior to the beginning of the school year, whether that's during the summer or right at the end of the school year before. I know that some schools and school districts like to plan all of their IEP meetings kind of at the beginning of the year, at the end of the year, to make sure that those IEPs are updated and everything is good to go. But they don't have to hold an IEP meeting directly before the school year to make sure that there's an IEP in effect. So they are required, though, to hold at least one IEP meeting no less than annually. So that means at least once a year, there should be an IEP meeting. It's your annual IEP meeting to go over any updated data, if there's anything that needs to be changed, and kind of see where things are. But that does not mean that there can only be one IEP for the entire school year. As the parent or guardian, you have the right to request an IEP meeting at any point in time. And the school or school district can also request an IEP meeting at any time. The only requirement under IDEA is that if an IEP meeting is going to happen, obviously you don't want to have an IEP meeting, once a week, and you just try to consolidate as much as you can. But as long as there's a valid IEP in effect at the beginning of the school year, you're good to go.
And I wanted to say, for those that may be joining us for the first time, LEA means Local Educational Agency. Just for those that might not be familiar, There are a lot of acronyms in IDEA. And if you are confused about something or don't know what it means, please feel free to put it in the chat, because you are probably not the only one. And we want you to, understand FAPE here is a free and appropriate public education. You will see that talked about a lot. We will try to explain all of these, but if you have a question, please put it in the chat.
So here's an example, and what we've tried to do is provide examples throughout to kind of give you some concrete examples instead of just kind of here's what it is. Celine is an identified student with an IEP. Her last IEP meeting was in February of 2021. So the LEA, right, the local education agency, the school or school district must hold an IEP meeting no later than February of 2022. But they were not required to hold one before the start of the school year. Just as long as they meet at least once annually, then you're good to go. Now, there is a caveat, and this was included in that last slide as well, that there are exceptions. So if Celine were to have some additional issues come up, if teachers were noticing or had additional concerns about Celine, if parents had some additional concerns about Celine before that annual meeting, then an IEP meeting has to be held to then address those concerns. So what happens to the IEP during school closures? Absolutely nothing. The IEP remains in effect. The IEP is still the IEP regardless if there is a school closure or not. The IEP is that legally binding document that tells you exactly what the school is supposed to be doing and exactly what your student requires, those special education and related services, and it remains in effect as it's written. So the school is still required to provide those services as written, as long as it continues to provide education to all students. So if the IEP says that occupational therapy is provided in person in a group setting, 30 minutes once a week, that's exactly how that occupational therapy has to be provided by the school. So how can you make sure that these IEP services continue while there's a school closure? So you can do two things. You can be proactive. You can request to develop a contingency plan. That's one of the recommendations or one of the things that's included in the guidance from the U.S. Department of Education. And the contingency plan could be a separate document. It could be something within the IEP or prior written notice. I know that it's my understanding that the Department of Education, Delaware Department of Education has recommended the information being put in the prior written notice. It's not going to matter one way or the other. The information that's in there is what matters, whether that's in the IEP in a separate document attached to the IEP or in the prior written notice. But you can always ask the school, hey, I want to talk about what's going to happen if there's a school closure and how these services are going to be provided to my child. And then you could be reactive. So after the school closes and your child doesn't receive the services, you can then request compensatory education to make up those hours. So if the school didn't provide an hour or two of occupational therapy for 2 weeks of school closure, you can request that they make up those hours that that you lost, or that your child lost. So we're back with Celine. So her IEP included individual occupational therapy, or OT, once a week for 30 minutes to be provided in person. Wanting to be proactive, Celine's mother requested an Iep team meeting prior to the start of the school year to develop a contingency plan, and the LEA agreed to do that, and they developed a contingency plan. And in that plan, it provides for how Celine will receive her special education and related services if the school closes. And so we can kind of back to how often IEP teams can meet, right? Do they have to meet more than once a year? Depends. It's a lawyer, it's attorneys and lawyers' favorite phrase, right? It depends. So the annual IEP team meeting is the floor. That is the very minimum, right? Once a year minimum. It does not mean that you can't meet more than that. And as I mentioned before, you can request an IEP team meeting at any time. And if the school or school district refuses to hold that IEP meeting, they have to tell you why. They have to, in a prior written notice, explain why they don't think that that IEP meeting needs to be held. One other option that IDEA provides for is, instead of having an IEP team meeting during, between the annual meeting, this can't take the place of the annual meeting, but between those annual meetings, the parent and the school can agree to amend or change the IEP without actually having that meeting, that they can just agree in writing, we're going to change Celine's occupational therapy to an hour a week instead of 30 minutes. You don't have to meet in person. But the good thing, I think one of the positives that have come out of COVID is it allows, right, we've now seen kind of this explosion of virtual meetings. And so that's also, an option to do that makes it a little bit easier than trying to plan for something in person. But this is right, another option of just a written document to amend it. And I know that this is an issue that we've seen a lot, and I know it's a question that a lot of parents have, is who actually has to attend the IEP meeting, and do they have to attend the IEP team meeting for the entire time? And not all IEP team members need to attend. They don't need to attend either the whole thing or part of it, but there are some requirements for that. So before the IEP team meeting, if there is a member who is going to not attend the meeting, the parent or guardian and the school must agree in writing that their attendance is not needed. And it's normally the reason that they're not going to attend is because their area or related service is not being talked about or is not being changed. But if the area is going to be discussed, but that team member can't attend for whatever reason, then not only must the parent and school agree that that IEP team member is excused, but that team member must provide input in writing prior to the meeting. So all of this has to be done before the meeting happens. It's not something that can be done after the meeting. It's something that has to be done beforehand. And IDEA lists out a whole bunch of required IEP team members that generally includes somebody from the district. It'll include the general education teacher, if appropriate, the special education teacher, if there is one, related service providers, parent, and then the child, if appropriate. And then recently, Delaware changed their regulations, their rules for the eligibility criteria for IDEA. And they added some additional members that are required specifically for the eligibility meeting. So not the annual IEP team meetings or anything like that. It applies only for eligibility meetings. And those, I have the citation down there at the bottom, and you can go through there, and just depending on the educational classification of the student is going to determine who those additional members are. So here is an example. Celine's mother requested an IEP meeting because she noticed that Celine has been struggling with math. Although Celine's occupational therapist is a member of her IEP team, the occupational therapist would not be required to attend because Celine's occupational therapy related service is not going to be discussed or modified, right? This is strictly about Celine's struggles with math. So the occupational therapist is not going to have anything to do with that. So before the IEP team meeting, the school and Celine's mom must agree in writing to excuse Celine's occupational therapist. And if for some reason during the meeting occupational therapy comes up, you know, as the parent, you can say, you know, I'd like the occupational therapist to join the meeting, or let's, you know, reconvene at a later date to talk about the occupational therapy. Can these meetings continue to be held virtually? Yes, as long as it's appropriate. And as the parent, you have to agree to hold it virtually. I know virtual meetings have been helpful, but there's also, you know, positives to having the meeting in person as well. And so IEP team meetings can be held through alternate means for any reason, whether that's by phone, virtually, or some other way. Now, can the IEP team meet without a required member, without the parent? Generally, no. It's IDEA really prefers that the parent or guardian be involved in decisions that are being made about their child for obvious reasons, right? And so IDEA makes it provides very strict reasons for why or when a school can continue and hold an IEP team meeting without the parent. And that's if the LEA, if the school or school district is unable to convince the parent or guardian to attend. And that has to be after there have been attempts by the school to accommodate the parent, whether the parent is not available on certain days and there's been attempts to reschedule, or, you know, a parent can't come in person, so they have to attempt to, you know, allow the parent to participate by phone or virtually. And it's generally the practice in Delaware that, or it's generally expected that schools try to, the school try to contact the parent in at least 2 different ways, at least 3 times. So they have to try to reach out to you by phone, by email, by physical mail, in person, all the different ways people can contact people, fax, I don't know. I don't know how many people use fax anymore, but as an example, right? So they have to attempt to contact you at least 2 different ways, at least 3 times. And if you're in communication, right, then they can't, if you're saying, this time doesn't work for me, they can't then just hold an IEP meeting without you after 3 attempts, right? It's only after the parent says like, no, I'm not going to attend, then they can hold that meeting. But it's very specific.
Stephanie, we have a comment. It says, my experience as related to the excusal of personnel. So the previous slide, at a meeting, it happens when I arrive, I feel uncomfortable with that. Then they ask me to sign for who cannot attend the meeting. So you had put, let me go back to that. So you had put that the school, it needs to happen before the meeting. So it seems that this parent is saying it is happening before, but right when they arrive at the meeting. So do you have any advice or comments for that parent?
So I mean, first off, I would say if they are, if you're arriving at the meeting, then it's already too late. You're at the meeting. And the other thing I would say is if you feel uncomfortable continuing with the meeting without a particular member of the IEP team present, it is completely within your rights to tell the rest of the IEP team or whatever member is asking or is talking with you about the member to excuse. You can tell them, I don't feel comfortable continuing holding the meeting without this person, and I think that they're a necessary member, so I'd like to reschedule when they're available. Completely within your rights. And if the school gives you a hard time or decides to hold the meeting without you, it's a violation of IDEA. And there are procedural safeguards that you can then go through to resolve that. But yeah, if you don't feel comfortable, completely within your right to say no, thank you. I'll let's just reschedule then.
And then we have another comment here. If a student has already been suspended for 5 days and sent to a new placement alternative, do the days start over or do they continue? So I'm assuming that's the days for your annual IEP. I'm not sure what days, if they're talking about suspension days.
Yeah, IDEA, and I know, I believe next month we're
going to do a whole series
on
discipline in February. So just like this month, we had each week a webinar. Next month, we are going to have a lunch and learn that focuses particularly on discipline, manifestation, determination, and restraint, seclusion, and restraint. So we will answer that then, or you can certainly send us an email so we can talk to you about that.
And the dates for next month, we will be sending, we'll have a flyer for the dates, but I believe we said it'll be Thursdays at the same time as now, 12 to 1.
Yes.
So here's an example for the information about the last slide and schedule the meetings. And so school district is in the process of scheduling Horatio's annual Iep Team meeting. Horatio's guardian is unable to attend the meeting in person at the time initially proposed by the district. So the district has some options, right? The district can either attempt to reschedule for a date or time when Horatio's guardian can attend. They could allow Horatio's guardian to attend by alternate means, whether that's by phone or by video. But if the district cannot convince the guardian to attend, then it may hold the IEP team meeting without the guardian as long as they have documented their attempts to arrange a mutually convenient time and place. So as long as they have that documentation and they are completely unable to convince Horatio's guardian to attend, they can hold the meeting without him. So this is kind of getting into, during the pandemic, a lot, if not all of the school districts provided laptops or other technology devices for a child with a disability, or really all children who potentially didn't have a way to access virtual learning. So they provided laptops and other devices. So are they required to continue providing those if the student with a disability return to in-person learning? And so we have attorney's favorite answer, depends. So if the IEP team determines that the device or service is necessary to enable it to enable the child to receive free appropriate public education, then the school has to continue providing it. But the school should also consider whether there are other devices or services that haven't been provided previously that are needed to make sure that that student receives a free appropriate public education. And they should also consider whether parent counseling and training should be provided on these technology devices or otherwise. And if you want to learn or understand a little bit more about parent counseling and training or kind of other related services, we did a related services presentation that I believe is on PIC's website that goes through all of the different related services, including a good discussion on parent counseling and training.
Yes, we have on our website videos in a video portal. So if you go onto our website, you sign into the video portal once, and then you will have a passcode, a login and a passcode, and you can go and view these videos and other videos that are related.
Here's a question about social, emotional, behavioral, and mental health support. So we know that the COVID-19 pandemic has had a lot of unintended effects on our youth. And so with that being said, when should some of these supports be included in a student's IEP? So the IEP team, right, determines whether and which of these services is necessary for the student to receive a free appropriate public education. So that's an IEP team decision, which you as the parent are a part of, right? You're a member of that team. And the need can be identified through either an initial evaluation, if it's a student who has not previously or who does not have an IEP at the moment, or it could be during a reevaluation. And in the case of a student who already has an IEP, the IEP team can be reconvened to address that concern. So if you've already had the annual IEP team or the annual IEP meeting, right, you can always request another meeting in between those to address those concerns. So here's an example. So after returning to in-person learning, Shay's teachers noticed that she is starting to seem detached and is not only failing to make progress on her goals, her academic goals, as well as her IEP goals, but she's also regressing. And Shay's father has noticed this and actually some more concerning behaviors at home. So the IEP team can meet to determine whether these supports are needed to receive free appropriate public education, right? Whether Shay needs some kind of emotional, behavioral, or mental health support. They can agree in writing to amend the IEP without a meeting. So if both the school and the parent or guardian agree, can just add something into the IEP without even having to meet. Or they can conduct or update a functional behavior assessment and then implement a behavior support plan. So the functional behavior assessment is a special evaluation that is usually used to develop or create a behavior intervention plan. And it typically will involve identifying some what the target behaviors are, what those the behaviors that are of concern, what could potentially be causing those behaviors, and then what kind of how those behaviors are addressed. And then the behavior support plan takes all that information and kind of comes up with, if if Shay has this behavior, this is how the teacher or school staff member would respond. So there's a way so that it kind of gives another way to address those behaviors for Shay. It should be noted, though, that related services, including social emotional behavior, mental health support, right, counseling, or anything like that, has to be provided by personnel who are adequately trained and prepared to provide those. So if it's a counselor who's providing emotional support, right, they have to be adequately trained to do that. It can't be like I don't know, one of the, a custodian providing that, right? I mean, that's a stark example, but they have to be adequately trained and prepared. And then, like I said before, we have a whole presentation on related services if you want to learn a little bit more. So is the IEP team responsible for addressing school-related health needs of a child in the context of COVID-19? So yeah, in general, eligible students with disabilities who need school-related health services are entitled to them as part of their free appropriate public education. It's what they need to access the general education curriculum. So if a member of the IEP team believes that the student needs some COVID-19 prevention strategies or risk measures, then the IEP team must consider whether and to what extent those measures are necessary. So those strategies could be included either directly in the IEP, or they can be included as a health plan attached to that IEP, which I believe is the case for students who have allergies. They have a health plan attached to the IEP. This is not necessarily an issue here in Delaware, but it is in several other states who have these mask mandate bans. But state or local rules, laws, and policies that limit an IEP team's ability to address these concerns by adding in some of these prevention and risk procedures and strategies, it's considered a violation of IDEA. So if a child needs something to access the general education curriculum and there's a state or local law that's preventing that, it's a violation of IDEA. So here's an example, right? Joseph is a student with complex medical needs and is at an increased risk for complications from COVID-19, whether because he has asthma or diabetes or any of the other listed health disorders for complications. So the IEP team must meet to discuss what school-related health services he may need to return to school in person and continue to receive a free appropriate public education. So after the meeting, his IEP now includes mask requirement and more frequent hand washing. And I will say that the same holds true for those students who might not be able to wear masks if there is a mask requirement because of either issues with having things on their face or other things. The school still has to, the IEP team still needs to meet to discuss strategies, maybe other things that can be done instead of having a mask on the face that can still accomplish the same goal of keeping that student and others safe. But it can't be prevented, right? Because can't prevent that student or force that student to wear a mask if you know they can't for health reasons. So how should the IEP team address the adverse impacts of educational disruptions due to the COVID-19 pandemic? So as I mentioned, right, the pandemic has had a lot of unintended consequences and a lot of has kind of caused more issues, not just related to health, but also with education, right? So the IEP team should ask this following question: may the student have new or different needs than what was determined prior to the pandemic? So that could be new needs related to long COVID, which we talked about last week. If there's complications from COVID, if it's caused some additional anxiety or difficulty focusing, you know, those are some new needs, right? And then whether there's some different needs. So consider whether there's lost skills or lack of expected progress toward those goals, whether there's, you know, any updated data, if present levels have changed, if they've regressed. Should look at all areas of need. So if it's a student who is has the educational classification of learning disability, and you know all their IEP is learning disability, well, they may have new or different needs because of the pandemic. So the IEP team should look at and consider all areas of need, not just those related to the learning disability. And then whether there needs to be implementation of any COVID-19 prevention measures or strategies. And can you go back to the slide real quick? In terms of the IEP, when you're looking at updated data, it is completely okay for the IEP team to revise goals to reflect present levels. So if a student has regressed, it's completely okay for the IEP goal to reflect that and to kind of be brought back a little bit. But the data that's gathered on that has to be good data, right? It has to be comprehensive, and it has to address everything in order to make that change. And Tika, it's my understanding that copies of the presentation are going to be provided.
Yes, it will be in the video portal in a week.
Yeah, that's one of the reasons there's so much words on the slides, right? I typically don't like a whole lot of words on PowerPoints because then you get into the habit of just reading what's on the slide. But we wanted to, make this a resource as well as a presentation. So something that you can take and like, here's what I have. So how should okay, yep. So now we get into kind of what happens after, right? If there's been some possibly some issues with students receiving their needed services. So then we get into compensatory services. So this is what we call an equitable remedy. And it's generally provided when a school or school district fails to ensure that student receives a free appropriate public education. And it's generally the Iep team who determines the student's need for an extent of those services. And in law, we have like equitable, which is not money. So equitable remedy, those are basically services or programs or other things that can be provided to make up for that failure to provide a free appropriate public education. And so generally it's a consideration of that student's present levels, their previous rates of progress. So if they were progressing, at a particular rate prior to the pandemic, and since the pandemic, they're still progressing, but not as quickly as they have, that would be something to consider. And then the frequency and duration of special education and related services. So if that student should have received, occupational therapy 3 times a month for 30 minutes, but only received it once a month during the pandemic. And states, Delaware has to ensure that these services are available for eligible children denied a free appropriate public education during the COVID-19 pandemic. So these compensatory services are available always. It's always the remedy when there's this failure to provide a free appropriate public education. And that includes during the pandemic. So I know that the Delaware Department of Education has released guidance, and there's a parent-friendly version on PIC's website about recovery services and unfinished learning and compensatory education and all that. And that's not traditional compensatory services. That's not offered all the time. That's just what's being looked at in terms of COVID. What this is all the time, as well as during COVID. You can't, these still have, this remedy is still available even for the what happened during the pandemic. So these are some examples, and these are similar to what is in the federal guidance, but just more real world. So Alice's initial evaluation, right? Alice has never been identified as a student with disabilities, but her initial evaluation after the parent sent or gave parental consent was delayed. So Delaware requires that after receiving parental consent, the initial evaluation is completed within 45 school days or 90 calendar days, whichever is less. That didn't happen here. So this is an example where compensatory services could be provided. Second example, OT provided to Celine during the pandemic was not appropriate to meet her needs. Maybe she needed it in person, but the only way it could be provided was virtually. Wasn't there to meet her needs, wasn't appropriate for her, not a free appropriate public education. So maybe she needs compensatory services. Joseph's physical therapy and behavioral intervention strategies included in his IEP could not be provided virtually. Same thing. Maybe Joseph should have compensatory education to make up for that. And then Gregory's transition services were not provided during the pandemic. So maybe there should be some compensatory education for him as well, since he did not receive a service. Big one. What if you graduated during the pandemic or turned 21 and then no longer received special education and related services? Guess what? You can still get compensatory services. Always. It is to remedy past failures. So if it was a failure and you were still eligible at the time of the failure and it happened, you can get, possibly depending on the situation, right? You could be eligible for compensatory services. They're provided as a past failure, and typically for children who are over the age of 21, or for individuals, not a child necessarily anymore, they can take the form of an additional period of eligibility. So you could still get some services for that. There was a case recently where a student who was 27 was awarded compensatory services based on a school's failure when they were still eligible. So just because you turn 21 doesn't mean you can't get remedy for any past failures. And then extended school year, it can be provided beyond the normal school year. And it doesn't have to be just during the summer. It can be during breaks, can be on the weekends. It's whatever that child or student needs for a free appropriate public education. And it has to be done in accordance with the student's IEP. So all the same services must still be provided. Special education and related services. And it's to prevent or slow severe skill regression. So the following question should be asked: will the learning that occurred during the regular school year be significantly jeopardized if extended school year services are not provided? So is there going to be slippage? Is there going to be regression if they're not provided with these extended school year services? And there's some considerations that are listed down there. And just a note, ESY is not compensatory services. And they are not mutually exclusive, which means your child could be eligible for both ESY and compensatory services. It's not one or the other. And then what should IEP teams consider for students who maybe missed out on transition services? Consider whether their needs have changed, whether they should receive compensatory services, and whether or not they're still making their expected progress and their IEP goals. So prior to COVID-19 pandemic, Raul's transition goals centered around his goal of working as a cook in a restaurant. But during the pandemic, his interest shifted and now he wants to be a nurse. So the IEP team is going to have to, kind of go back to the table and revise those transition goals because his interests have changed, right? His goals shouldn't be centered around being a cook in a restaurant, but rather what he's going to need to transition into working as a nurse. And I know that we're running up on time, Tina. So we'll, if you as the parent request virtual instruction, does the school have to do it? Attorney's favorite answer, it depends. If the school makes virtual instruction available to all students, then the student with a disability, they have to make sure that their needs can be met through virtual learning as well, and that they have an IEP that provides for all those supports that they need for a free, appropriate public education. But it still has to provide, the school still has to provide that child with meaningful opportunities to be educated with and interact with non-disabled peers. So under the IDEA and the federal government, you know, the IDEA was created because individuals and students with disabilities were educated separately from non-disabled peers. So to remedy that, right, we have inclusion. So virtual learning has historically been considered restrictive. And so in our pandemic days now, it can be considered less restrictive as long as it's provided to all students and provides meaningful opportunities for that education and interaction with non-disabled peers. And so beyond the guidance, this is your procedural safeguards, which are available on the Delaware Department of Education's website. And they should actually be offering it to you at every IEP meeting you have. They generally offer a copy, and you can agree and get a copy or not. Should always get one. So these are the things that you can do if you believe that your students' rights have been violated. So there's facilitated IEP meetings, which you would have somebody from Spark, and I knew I was going to do this. And I'm hoping Nidra is on here and can put in what Spark means. Something for amicable Yep, they are through the University of Delaware, and they're contracted with the Department of Education to provide mediation services. And they do facilitated IEP meetings where they'll come and kind of be a mediator and help facilitate where there's disagreements between members of the IEP team. Spark mediation, so you can request mediation directly through Spark. And the request generally goes through the Department of Education, who then send it to Spark for the mediation. Then there's state complaints, which have a special education partnership for the amicable resolution of conflict. Thank you, Tika. State complaints have a 1-year statute of limitations, which means you have 1 year to file the complaint from whenever the disagreement or issue happened. Due process complaints are 2 years. And normally before the state complaints and due process complaints continue, they'll offer mediation. So they'll offer the mediation through Spark, and you can do that before continuing with the complaint. State complaint is like there's an independent investigator who will investigate the issue. Due process complaint is more like a hearing in front of a panel of judges, or they're not judges, but in front of a panel of individuals who will then decide. And then you always have the option of filing a federal OCR complaint with it's the U.S. Department of Education Office for Civil Rights, or filing a report with OSEP, which is the Office of Special Education Programs within the U.S. Department of Education. And then, like we had said earlier, if you have individualized questions or need some technical assistance or information, you should feel free to visit our respective websites or give us a call, and our information is on the next slide, I believe. Yeah, so as a reminder, this is just general information, not intended to be legal advice. Every person's situation is different. So if you do have specific questions, feel free to reach out.
Yes, and this information will be available within a week in our video portal. We also have next week, we will talk about Part C in the same format. So please register for that, bring your questions, and we look forward to talking with you then.
And please fill out the survey.
Yes, please fill out the survey. Thank you so much for joining us.